deed to be admissible, you need to prove that it's been stamped. And then it's different state to state as well, in terms of the amount, whether you have to stamp. So it's not a huge, it's probably not the worst thing. Probably not the worst thing. All
Well,
right.
some very interesting problems there. Thank you for sharing.
Yeah. All right. Well, let's move on to the first topic. I'm going to come back to lost trust deeds later on. But I'm going to start with, well, an example of something going very wrong. Whether someone is a beneficiary of a trust or not. So this is based on a case. The case is called Beneficiary, and there's a number of court cases that have come as a result of these facts. The one that I'm going to focus on is a Queensland Court of Appeal case from 2020. And I'll start with this as a quote. So what the decision says is, in the absence of rectification to a trust deed to add Mr. Lamar as a beneficiary, any distribution to him and his former and current spouses will have been made without authority. So you can see what we're getting at here. In this case, we had a trust established in 1977 on the behest of a Mr. Lamar. And the trust continued its merry existence over time. It made distributions to Mr. Lamar. It also made distributions to his first wife, whose name was Susan. And following a divorce between those two parties, later on made distributions to a new spouse, Margaret. Well, what was the problem? Well, the problem was Mr. Lamar wasn't a named beneficiary of the trust. And by implication, he wasn't a beneficiary, and also his spouses would only be beneficiaries if essentially Mr. Lamar was named in the deed and he wasn't. So, okay, well, if they're made without authority, what's going to happen? We'll put some pretty severe consequences. So what the trustee did is it sought rectification of the trust deed, essentially going off to court and saying, dear judge, there's been a very obvious error. We need to have this fixed. Can you make that order? And this goes to show how hard it is. So going through what would be the consequences, first of all? Well, if they're made without authority, those people aren't entitled for trust law purposes. So they can't actually call on the money. That might be relevant for perhaps asset protection or a family law issue. For tax purposes, they're also not entitled, which means that they can't be assessed. But as we know, the trust, someone's going to be assessed. So that could be the trustee, might be another beneficiary, and it could be that it's a trustee assessment, which is perhaps the worst of all outcomes, because not only is it at a top marginal rate, but you may have issues about the period in which the commissioner can go back and actually review. So but looking at something like this, the question is, well, who would even be entitled if these are not, all these distributions over time haven't been made with authority? Who would be entitled, both from a trust law perspective and actually demanding the money, and also from a tax law perspective, and who's going to get assessed on those amounts? So the case goes through what's called rectification for a unilateral mistake. So that's the legal basis here. And the parties to the decision was essentially the trustee and Margaret. And Margaret opposed the rectification on the basis, essentially, I think, for tax reasons, because what it says in the judgment is, well, if Margaret was not a beneficiary, she would be entitled to a refund of $8 million. Sorry, she'd be entitled to a refund, but otherwise she would have a tax liability of $8 million.
Okay.
So pretty huge consequences. Pretty huge consequences. Now, we don't know all the ins and outs about, well, okay, who would tax fall to otherwise and all of that. But we know that the ATO took interest in it. There was an audit, and that might have been, and I suspect that is what led to the rectification being, because otherwise people don't look at these issues. They don't go look at their trust deed every day, or am I a beneficiary or not? So then it goes to, okay, well, if a court's to order rectification, there's a specific test that needs to be applied. The test is pretty a high bar. So what it requires is there has to be clear and convincing evidence at the time the trust deed was exercised that the settlor had some intention that isn't actually written in the document. And not only that, it has to be demonstrated with clarity and it has to be sufficiently precise. So in other words, it needs to be crystal clear that the people setting up the trust deed had a certain intention and that it's not in there. And it needs to be crystal clear exactly what that intention was, not some vague hocus pocus thing. It has to be, again, crystal clear. Maybe the one where, you know, someone puts in like they just don't put the year in correctly. They put in, instead of 2080, they put in 1080 as the vesting date for the trust. So maybe something like that would be clear that, well, no one would have intended that. And it's very clear they meant to put a 2 instead of a 1, for example. Now, then it goes to, okay, well, what did the evidence actually say? And the first point is, this is hard because you're looking back at evidence more than 40 years ago at this point. Going back to 1977 and trying to work out what did the parties intend in 1977? And what evidence is there to actually demonstrate with clarity, sufficiently precise intention, all that sort of stuff. And the problem is that, well, the parties said that there really wasn't any intention about whether or not spouses should be beneficiaries or not, essentially. The evidence said that the parties intended to set up a trust to benefit their family in a broad sense. But there wasn't any evidence at all, really, either way about whether or not spouses should be included or not. Because sometimes you have a client that says, I don't want to include spouses. I want to make this a bloodline trust. Other times they say, no, I do want to include spouses and, I want to include everyone for maximum flexibility. So if there's nothing either way, then you can't sort of just infer that, oh, well, most trust deeds put spouses in, therefore spouse should be in as a beneficiary. So, and then the end of that quote essentially is that Susan, the first wife, thought it was a good idea to establish the trust to benefit her husband, herself, and the family, but there's no evidence about what interests that she or her husband would actually have. Would they be capital beneficiaries? Would they be income? Who knows? And the only evidence is that it would be for the benefit of ourselves and our family, but that's such a loose statement that it's not enough to get over that pretty high bar. So what does that mean? Well, the court said, no, we're not going to grant rectification. So you can see that it's actually a really high bar to, if you've got a mistake in a trust deed, this is the test that essentially needs to be applied. Is there clear and convincing evidence? Firstly, that it's a mistake, and secondly, exactly what it was supposed to be. So it can be really hard when things are just not included.
Have you had any successful rectifications before?
No, thankfully not. I've never had to go do it.
It's really only for like typos or something blatantly erroneous, right?
Yeah. So I've done them in a private setting without seeking court approval, but it's really for things that are extremely minor. If it was in any way contentious at all, I mean, not even contentious, but if you really should be going off to court, depending on the consequences and what it is, then that's the proper solution. So I've put some takeaways here for this section. I sound like a broken record on this point because I've made it many times before, but read the deed. Are they a beneficiary or not? Are spouses included? Are they not? Are companies included? Are trusts included? Who's the excluded beneficiaries? All of that. If you have an issue identified, consider what the consequences would be. So assess the damage. Is it that this person's not a beneficiary and they've been distributed to for all these years? What's the consequences? What would that look like from a tax perspective? If it's something that's grey, is it possible that there's other interpretations? If it's some term hasn't been defined or hasn't been defined well, maybe there's an argument you could interpret it different ways. So maybe you don't need rectification. Is there some other way around the issue, like there's a different power in the trustee that could get the same result? I had one where the trustee didn't put eligible companies as beneficiaries, and it couldn't be altered either, but it had trusts as eligible beneficiaries. So basically we could distribute to a trust, and then that trust could distribute to a company. So we could kind of get around the issue. Is there a variation power that can be used? If you've failed on all those points and it's like, no, we've got a clear issue, is there that clear and convincing evidence? And if so, then which pathway should you go? Should you go down the route of a deed, or do you need to go off to court to get it fixed?
So a deed is a deed of amendment?
Yeah, it'd usually be a deed of rectification.
Oh, yep.
Something that's really administrative, clear typo. That's sort of where you'd look to a deed. But if it's anything more than that, yeah, you'd really need to be going to court, or if someone's litigating over the issue, or the ATO is involved, for example. So, final point on this managing invalid trust distributions. So, again, if you're dealing with these invalid distributions, assess the consequences. If there's someone who can't be entitled, you need to think about, what does the trust deed say? What do the distributions minutes say? You've got to work out sort of who's next in line. Is it the default beneficiaries, or is it somebody else? Depends how you've done your minutes. From a tax perspective, has the commissioner's period of review expired, both for who's actually been assessed and who should have been assessed? And if we're dealing with 4-year periods and everyone's lodged returns on time and all that stuff, really you can only amend the last 4 years anyway, outside of fraud or evasion. If it's the trustee that's assessed, now technically the trustee usually doesn't get an assessment because it doesn't have income. But what the commissioner says in a practice statement from 2015 is that the period starts from the lodgement of the trust tax return. So that's an administrative ruling. It's probably not based in law, but it is that there is some comfort about trustee assessments there. You can always consider out-of-time objections if you needed to, and ask the commissioner to treat something as within time. And also, if you've got a clear issue, voluntary disclosures to the tax office and managing penalties and things like that. All right, well, I'm going to move on to the next little topic, which is when a foreign trust becomes Australian. This is something that might not come up every day, but there are a number of jurisdictions that do trusts and do lots of trusts. So you might have a situation where you've got someone who's foreign who's become Australian and who's brought a trust with them. So the situation I see this coming up in is situations where you have a foreign resident, they've migrated to Australia, and there's a trust. It's either a discretionary trust, or it could be a deceased estate, for example, and they are one of the trustees of that. So they could be one of 3, one of 4, one of 2, with the sole one. But one of the traps is that you could have a situation where you have 3 individuals, they're trustees of an overseas trust, and one of them migrates to Australia. But the trap is that trust, because of that one trustee, would become an Australian resident trust.
The whole trust.
The whole trust, yeah.
Yep. Even though one person only has moved.
Absolutely. So it can be quite disastrous and difficult to reverse out once that's happened. So with the definition of a trust, whether a trust is resident, we actually have 2 different definitions. One is for Division 6 purposes, and one is actually for CGT purposes, which is another quirk of our beautiful tax system. So the definition of a resident trust estate for Division 6 purposes is a trust will be resident for an income year if any of the trustees were resident at any time during the income year. So in other words, for one day, there's an individual who's a resident, the trust is a resident for the full year. The alternative is if the CMC, Central Management and Control, the CMC of the trust is in Australia, again, at any time, the trust will be a resident. The point I made earlier, it's sufficient if there's individual trustees, it's sufficient if one of the individuals becomes a resident. If you're dealing with a corporate, then again, it's based on the residency of a corporate is based on CMC as well. So the CMC of the trustee could be in Australia. Corporate management, central management control. If you want to read up about that, the Commission has got a tax ruling and a PCG. It's a bit of a state of flux about corporate residency, but the principles about where central management and control is located are still all correct. The main consequence I see as a result of this, or I've seen in the past as a result of this, is if a trust becomes a resident trust estate, if it has accumulated income, then you will have Section 99 apply, or 99A. Whereas if a trust is not a resident trust, then it will, and accumulates its income. It has no connection to Australia. So the situations I've seen this come up in is in other jurisdictions where there's not so much of a driver to distribute income each year. And one of the trustees become Australian. The trust has then become Australian. Trust hasn't distributed its income. It's a resident trust. And all of a sudden the trustees, all three of those, are now assessed under Section 99 or 99A. So it's a pretty horrible outcome.
Is it like the profits have never been taxed in Australia before, something like that? Then 99 B applies?
I'll come to B later.
Oh, this is just 99A.
Yeah,
Okay.
This is just for income derived in that year. And
oh, I see.
Hasn't distributed it to anybody.
Okay. Yep.
So we then have another definition for CGT purposes. And for discretionary trust, it's the exact same definition, as in based on do you have a resident trustee or CMC in Australia. If you have a unit trust, you have a different test, and it's whether or not the unit trust has any property in Australia or carries on a business in Australia. So, I mean, any property is pretty broad. And then one of the following, either the CMC being in Australia or Australian residents holding more than a 50% interest beneficially in the trust. You can also have issues where a trust ceases to be resident. So you could have a trust that's been brought in and now the trust is becoming a non-resident again. Similar to individuals, there is an I event that happens when a trust ceases to be a resident. So which triggers CGT on, uplifts on market value, all that sort of stuff. The difference is with individuals, there is a rollover available, but with trust, there isn't a rollover. So if you have the trust that's come into the net, and then the individual's left, or they've changed the trustee to another person overseas, well, technically it's become a resident, but ceased to be a resident, you've got CGT consequences. For the more vanilla situations where you're just dealing with Australian, your run-of-the-mill Australian discretionary family trusts, you can avoid becoming a non-resident simply by having an Australian incorporated company as trustee. So that's probably one reason to... Sometimes clients ask, well, should I have an individual as a trustee? Should I have a company? This is another reason that, well, if it was an individual and they became a non-resident, then potentially the trust would become a non-resident too, with I2 happening. Whereas if it's a company incorporated in Australia, that's always going to be a resident, and therefore the trust is also always going to be a resident of Australia.
Understand. So yeah, I think this goes in line with Emily's question. So for trustee companies, the test is purely CMNC, Central Management and Control. It's not about the residency of the directors.
Not about the residency of the directors. And if a company is incorporated in Australia, it is always going to be an Australian resident as well.
Oh, okay. Yeah,
Yeah.
there you go, Emily. That's a good
So an
one.
Australian incorporated company will never not be an Australian resident.
Nice.
So that's a planning thing. I've had that come up where you've got individuals migrating to New Zealand with Australian discretionary trusts, for example. Well, maybe we want it to be a non-resident, maybe we want it to be a resident. And depending on your outcome to that, that might depend on what you do with the trustee.
Yep.
So now I'm going to move on to talk about Section 99B. And fun fact that the ATO is actually releasing material this week on Section 99B. They've been talking about it for 4-5 years,
Yonks.
maybe, a long time.
Yep.
And I forget the numbers of the references. They've said exactly what numbers they're going to be, but there will be a tax determination released on Section 99B, and also our favorite product, a PCG, practical compliance guidelines. So 99B doesn't come up anywhere near as often as, say, Section 100A, for example. So hopefully it's not going to cause the same amount of chatter. But it will be good to see, because there's been, as you'll sort of see, that this provision's really wide. There's a number of open questions about how it actually applies. Kind of similar in some sense to 100A. It's just that this comes up far less because it's really to do with foreign trusts. So 99B, well, this provision actually was inserted at the same time as Section 100A. And its purpose was there was a deficiency in the law at this point. And what people could do is essentially you could have a foreign trust. It's accumulated income over a number of years. And then after that, it distributes all the income to the Australian resident. And it does so as like a capital amount, and it's not taxed. Because Division 7A works on present entitlement in the income year. So if the income is in previous years, basically, you're not going to get taxed under Division 6. And of course, because it's a non-resident trust, it's not taxed under 99 or 99A. So we need something else. So the purpose of this provision was to tax accumulated foreign income of a non-resident trust that is distributed to an Australian. And that's essentially what that quote says. This is about the inclusion of the section. It'll require the beneficiary to include that income that represents something that hasn't been taxed in Australia. Now, interestingly, with the provision, there's actually nothing in the section itself that limits the provision to non-resident trusts. The EM talks about non-resident trusts. The explanatory memorandum does talk about non-resident trusts in its purpose, but there's nothing in the provision that actually limits it to non-resident trusts. So, for example, a trust could have been a non-resident at some point. Now it's become a resident, or maybe it was a resident the whole time. There's nothing in the words of the section that limit it to non-resident trusts. And these type of things are problems because there's a number of other avoidance provisions that are getting at certain things, but then they don't have those words in the legislation. So just a point to note, and I expect this will probably be clarified in the Commissioner's determination. It's really wide. It covers not only distributions themselves, but it covers loans, indirect payments, other benefits provided. And what 99C says is all those things are basically treated as distributions. There are really limited exemptions to this. So the main exemption is that the amount needs to be corpus of the trust. Not only does it need to be corpus, but it needs to not be attributable to something that would be income if it was derived by an Australian resident. So it's not enough that it's corpus. It needs to also not be something that would have been income if the trust was Australian. So in other words, it really needs to be a gift or a settled sum in the trust. If it represents corpus, but it's because it's just like a reinvestment of earnings, that doesn't qualify you.
Oh, like CGT discount doesn't qualify.
No, none of that
Oh.
qualifies. It has to be either a gift, settled sum, or someone's passed away and money's like, it's a gift as well, but someone's passed away and the money's gone to a discretionary trust or a testamentary trust or that sort of thing. Anything else is not going to be included.
Yep.
And another sting in this is there's no recognition of any periods that a beneficiary might have been a non-resident. So you could have a non-resident trust that's been running for 30 years, distributing to non-residents, but it's got this big amount that's built up in the trust, and then that non-resident becomes Australian, and then a distribution's made to that non-resident, which they're thinking, oh, this is corpus, and oh, well, somehow I'll get market value step up on the date that I become a resident. Well, there is none of that. So there's absolutely no recognition that a person could have been a non-resident for a lot of the period, which is pretty unfair, but it's just worth highlighting because that's just the position. How I can see this coming up, and how I do see this coming up, is through this example that I'll give. So I'll give two examples. One's about inheritances and one's about CGT. So in this example, we've got a foreign trust. It's received $2 million following the death of Aaron's parents. The trust stays around for 5 years, and that time the assets of the trust are worth $3 million. And the trust says, okay, well, Aaron, I'm going to lend you some money. So it's a relatively simple scenario. In this scenario, we've got the trust making a loan, which is deemed to be essentially a distribution. It's to a resident. So we're in section 99B. And then what would be excluded? So we'll start with 3 million. Well, the 2 million is essentially corpus. It's essentially a genuine gift. That would be excluded. So the $1 million would be included as assessable income under this. And there is also a very punitive interest charge that would apply as well, which can be very, very significant in addition to the $1 million of assessable income.
Yeah, this could be quite common.
Yeah, it often comes up with inheritances, because that way with inheritances, there's more sort of trusts that exist than otherwise, because discretionary trusts, otherwise you really see them mainly in New Zealand and the UK otherwise.
I see.
So I've just changed these facts around slightly. So we've got the foreign trust, Aaron again. Again, the foreign trust received $2 million on the death of Aaron's parents, and the trust has been liquidated. The assets worth 3. Now, this time, the only difference is Aaron has 2 siblings, and the siblings are non-residents. And it's great that everyone will get 1/3 each. So everyone's getting $1 million each. Question is, well, how do you work that out for Aaron? Is it that she has, like, does she get a slice of that assessable income, or can she take hers as corpus first and not take any of the earnings? So there's not a clear answer to that question, but I think you would try to say in that type of situation, you could perhaps take the corpus for the Australian resident and leave the rest to the non-residents, assuming that works for their tax position.
It's like proceeds allocation, right?
Yeah, absolutely. The final issue on 99B, and just another area of sort of unfairness with this, is let's say you have a situation where you have a foreign trust that has Australian ASX shares. Again, we have Aaron. The foreign trust has made a capital gain of 50,000, and the foreign trust says, I'm going to distribute that gain to Aaron. Aaron's got capital losses herself of 40,000. Now, the $1 million question is, what's the tax treatment for Aaron? What do you think, Joyce?
So 50K gain, and everything goes to Aaron.
Yep. Your losses are 40,000.
10K?
You think so?
Net?
You're like, no, this, yeah, you're setting me up to fail here. I am setting you up to fail. So there's a tax determination on this. The answer is 50,000 of assessable income, no discount.
Why?
Yes. So in other words, what the commissioner says, and it's in the TD that I've listed there, is when the foreign trust distributes and it gets hit by 99B, it loses its character. So it's no longer a case of streaming a capital gain like it would be with an Australian resident trust, but it's just an amount of income. So, and because it's a special income, it's not a capital gain. So you can't apply capital losses. And again, it's not a capital gain, so you don't get the general 50% discount. Really unfair.
Yep. Yep.
So you can read that in your own time. Yeah, there's some unfair issues, and I expect, again, there's a TD and a PCG coming out this week on Section 99B, and I know I will be printing them off and reading them straight away. Yeah, looking forward to it. But it's a complex area, so the takeaway here is if you get any foreign deceased estates or trusts from other countries and you have any connection to Australia, immediately put your sort of red flags up to check and think about 99B really carefully.
All right. So we've got about 20 minutes left, Andrew.
Yep. All right. So lost trust deeds. I saw there was a lot of comments about lost trust deeds earlier on. We've got an interactive question. Do you have copies of the trust deeds for all your clients' family trusts?
It's all anonymous, so we can't tell if you have. No dubbing
There's no
in here.
TPB mandatory reporting from this seminar.
That's right. We're not tax agents here. So, are you a tax agent, Andrew?
No, we cancelled our registration.
Anyway, let us know. Do you have copies of all the trustees for all your clients' family trusts? Yes, no, or only for some clients. This is a bit of a fun one. Let's see what people say. Thank you for voting.
Do I need to click to get to it? I think.
Yeah.
Yep. Oh, yep.
Very good. Most of you all have it. Yay.
So there are no easy answers for lost trust deeds, but what I'm going to do is just talk about a fairly recent case where the clients did lose the trust deed and the potential implications of that. So the case is Mantovani and Vanta Proprietary Limited, number 2, 2021 Supreme Court case. And this is the original decision. So in this case, we had a trust. It was established in 1976. It had various land that was transferred, land in regional Victoria that was transferred by Teresa Mantovani to the trust. She had 4 children. The directors of the trustee were 2 of those children, Rocky and Nick, and the trust had distributed solely to Rocky and Nick for many years. You can see there's going to be some problems with this anyway, because basically 2 kids are on the outer and 2 are in the inner circle.
This is Owie's case.
Yeah. So Teresa died, and a child of Teresa Giovanni asked for documentation regarding the trust, asked for a copy of the trust deed. And at that point, it so transpired that the trust deed had been lost. But there was something that existed. The schedule still existed.
Okay.
That schedule had the name of the trust, the date of the establishment, the settlor, the trustee, the settled sum, pointers, beneficiary, all that stuff. Problem is that, well, that's just a schedule. Like, without the actual document itself, who knows what those, yeah, we can kind of infer what a settlor does and what a pointer does, for example, but without the actual trust deed, you don't really know. Like, you can guess, and you're probably right, but you don't actually know. So what happened? Well, we had an initial decision, and what this initial decision said, is that the trust failed for uncertainty. there was not sufficient certainty about the constitution of the trust, and therefore it failed for uncertainty. And it had been administered based on guesswork.
Mhm.
What did that mean? Well, that meant that the assets essentially reverted back to Teresa Mantovani. And what that meant is essentially the assets went into her estate. And what that meant is that they could be challenged through her will rather than as assets of the trust. So there was a lot at stake. What the initial judge said was, well, the evidentiary requirements for certain, we need certainty. And that was, and these words will jog us back to very early on in this presentation, clear and convincing proof, not only of the existence, but all the contents. In the same proof required to establish rectification.
Yeah.
So I said, well, that's not, well, we don't know the contents. All we got is a schedule. So that's not clear and convincing proof. So in other words, the trust fails. The assets should be vested in Teresa because she's the one who's contributed. She's passed away. The assets go to her estate.
Mhm.
Now, that sort of sent a few shockwaves off because, I mean, that's got pretty dire consequences. And as we saw from the poll, there was at least a few situations where the trustee might not be there.
Yeah, like 30% of the time. If
Yeah.
this is the right sample, good
Yeah.
sample size. Well, there are about 500 of us here, so quite a big sample size.
Yeah. So reassuringly, or perhaps reassuringly, that decision was appealed to a Court of Appeal decision. And essentially, the Court of Appeal said the first judge got it wrong. And the test isn't clear and convincing proof. It's sufficient if it's been established on the balance of probabilities. So balance of probabilities, 50-50, just over. Clear and convincing proof, I don't know, 90, 91%.
Yeah,
Who knows?
yeah.
This is hard stuff when you've got one judge saying one thing and another, appeal saying something else. But they looked at it, otherwise they looked at it through the same lens about, well, is there a certainty of intention, subject matter, and object? And has that been set, established on a better than 50% basis? And they said, well, yes, they have been established because the schedule exists, there's been financial statements, the trust tax returns have been done, and there is evidence that Teresa intended to contribute assets to a trust to start with. So that's enough to meet those certainties. And the trust said that the trust existed despite the trust deed being lost and the terms being not capable of precise ascertainment. Now, I know the question that you all might be thinking now, well, okay, what do you do then? Like practically, how do you actually administer? If the trust deed doesn't exist, or all we have is a schedule, financial statements, tax returns, etc., it's pretty difficult to actually administer because how do you know the powers? Simple. How do you know the powers? You don't. So what the court notes this as well in the decision, and this is really what you kind of need to do if you're faced with these situations, and it's not an easy answer. What they said is it's been open, it remains open for the trustee to apply to court for judicial guidance as to the administration of the trust, notwithstanding the loss of the trust deed. So good, the trust exists, and the trustee can go get guidance at any point from the court. And in fact, in this case, the decision, the applicants actually had to make an undertaking that they would, I think it was within 3 months, they would actually go and make that application to the Supreme Court for orders to be able to administer the trust. And Joyce, you said earlier, owies, the court notes that it does remain open to the aggrieved beneficiaries to take whatever steps, says John here, Giovanni, they're the same person, for John to take whatever steps that he deems appropriate in relation to the actions of the trustee and directors, including in relation to distributions of trust income. So that's a topic for another session about the owies decisions about attacking trust distributions and things like that. But they note that, okay, the trust exists. The trustee can go get judicial guidance, but there still might be an action for this beneficiary who's been left on the outer because the trustees have failed to do this the whole time. And they've only done it, now. So unfortunately, the takeaway is really, if you're faced with this situation, this is really the only option, particularly if you're talking about something with lots of property, wealth, multiple family members. Some people want to sort of just do like a deed of confirmation, which is essentially sort of everyone signing a document saying, yep, the trust deed's been lost, but these are the terms. It's better than nothing, particularly if everyone agrees to sign it, but it's not the gold standard.
Understand. So what does it involve, getting judicial guidance? I mean, is it just going to your lawyer, let them figure it out?
Going to a lawyer, letting them figure it out. I mean, you'd be presenting the court with the evidence around, what you believe the terms to be, the schedule, when it was created, things like that. And then you need to be clear on what you're actually seeking as well.
Okay. Yeah. But it's always when a dispute arises, yeah? Somebody dies.
Yeah.
Dispute arises, that's when all these documents become so important.
Yeah.
And that's where all the spiders
audit.
come out.
Yeah, absolutely.
An audit, yes.
An audit as well. If they ATO asks for a copy of the trust deed and don't have it, I mean, they're not going to be it's not the same as a beneficiary in a family dispute, but, as you could see from the first Beneroon case we talked about, it can lead to real issues. And if you're put to the proof and the ATO says, well, we don't think you're a beneficiary and you don't have the deed to prove it, how can you prove that the person was a beneficiary?
Yeah. And then, all the tax issues arise from that as well.
Absolutely. These last two will be pretty quick. Disclaimers. So we've got a little quiz firstly. Beneficiaries can disclaim trust income at any time. True or false?
True or false? So disclaim means they can say they don't want it?
Yep.
Something like that?
Yep. Put the big hand out saying, I don't want it. I've been the trustee, you've made me presently entitled and I don't want it.
Thank you for voting. Let's
jump to let's see. Look at
it's
that.
a bit of a tough one, this one.
Yeah.
It's 50-50 chance.
Well, I mean, the good news is everyone's right in a sense, because the actual answer is they can disclaim at any time, but it might be that the tax consequences will not change regardless.
Oh, okay.
So everyone's
stuck
right
with the tax. You can say, no, I don't want the money.
Yeah,
give you back the distribution.
Yeah.
But you're stuck with the tax bill.
Yeah. So what a disclaimer is, essentially the trustee has made someone presently entitled, and it's a concept that anybody can, whenever someone makes a gift, the party that's receiving the gift or would receive the gift has the opportunity to say, no, I don't want it. So in any gift type situation, including a trust distribution. Why might it arise? It might be a tax reason. It might be an asset protection reason. It might be a family law reason, although that's kind of fraught with risk. But those are some of the settings that I've seen it in. The prospect with a disclaimer is that it's generally retrospective, as in a person, they've been notified that they've got this gift, and then they've got like a reasonable opportunity to say, I don't want it. And that will, from a general law perspective, the law will treat that as being that they never had a gift. And that might be relevant to, if they passed away and what's in their estate and things like that. Now, if we go to tax, we've got section 97, which assesses beneficiaries on their share of the net income of a trust based on their present entitlement to a share of the income of the trust. And what the law now says, based on a High Court decision from 2 years ago, is when you look at present entitlement, that's assessed at immediately before the end of the income year. And it doesn't matter what happens after that. So it's not something you can test at some later point in time. You need to test it at that point, as in just before midnight, were you presently entitled? And if you disclaimed after that point, you're still going to be assessed for tax.
Yep. There's no other testing period, right? It's just
Absolutely.
before 11:59
Yes.
p.m.
Yeah.
on 30
The
June or
trouble, the
whatever.
trouble is that you might not even know that you have a present entitlement at that point. Yes, if you know, you can disclaim, and as long as you disclaim before midnight, that will be effective. But if you disclaim after, it just doesn't work. And I've come up with an example that it's extreme, so take it with a grain of salt. But in this example, we have a discretionary trust, $1 of ordinary income, $1 million capital gain. Deed defines income as ordinary income, so $1 is the trust law income. The trust makes a beneficiary presently entitled to 100% of the income. So what happens there? Oh, sorry. The trustee then tells the beneficiary about it on 1 July. Well, what's the tax position of the beneficiary? Now, using the proportionate approach, they'd be assessed on the $1 million capital gain, right? What's the entitlement? Well, it's $1. It's also negative if you factor in the tax liability that's going to arise from the capital gain. And a disclaimer will not change the position. If it's done after 30 June, it does not change the position. So it's just another example of how Division 6 has some fundamental things that are just completely broken with it. And this is an example. Like, how could this come up? It's a bit of an extreme example, but you can see it's kind of like the distribution is a bit of a poison pill, and there's no way to get out of it after 30 June. So you can disentitle yourself of the trust law entitlement to $1 in this example, but you can't get out of the tax position. Finally, so I want to leave some time for questions and takeaway. Just quickly on UPEs and Division 7A. I just wanted to do a little bit of a reminder about subdivision EA of Division 7A. Now, this was inserted in 2004 and it applies from 2002. How it applies is it looks at where a private company is presently entitled to income, but hasn't been paid that income. What's happened is the money's gone elsewhere. It's gone to a shareholder or an associate of a shareholder of the private company, whether as a loan, a payment, a debt forgiveness, all those sort of things. And what it does is it treats a deemed dividend as arising between the private company and the end individual or trust. Now, you might think, well, isn't this already covered by Division 7A anyway? Because UPEs are part of Division 7A. Now, it's a real kind of vexed question, and we're a bit of a state of flux with this at the moment because we've got the Bendel litigation, and depending on the outcome of that will depend on how much, what work subdivision EA actually does. What I see in practice, and the one to be aware of, is where you have pre-2009 UPEs, and they've been quarantined in the balance sheet, but after that point in time, there's been loans, or not even after that point in time, at any point in time, there's been loans or debt forgivenesses, payments, etc., from the trust elsewhere. You may have a quarantined UPE, but you still have a problem under this division, so you still will have a deemed dividend. This has become way less relevant since 2009 because of the Commissioner's views about UPEs, but those views have obviously been challenged through Bendel. If the taxpayers win in Bendel, it doesn't give a carte blanche to just ignore Division 7A. It gives so long as the money stays in the trust, so the UPE money stays in the trust, you won't have an EA issue. But as soon as the money goes out of the trust and there's a UPE there, you will have an issue under this section. Joyce, you want to?
That was it?
Yep.
Awesome.
That's the end of the issues. Yep.
Great. So before we move on to Q&A, we do have quite a few Q&As. Just wanted to say, for those that are new to us, if you found the session useful, you're welcome to start a free trial with us. Go to taxnuggetsacademy.com.au. We also have team subscriptions if you're interested in getting us for your staff. And also, our next free live event is on the 26th of August with Lisa Gregg on the new TASA changes. So all about dubbing in other accountants and the latest one, dubbing in your clients, and also dobbing in yourself, potentially, if there are any significant issues that your clients need to be aware of before they engage you. So a must attend event.
I expect you're going to have 10,000 attendees for that one.
Assistant Nugget, if you can pop the link in the chat for registration, that'll be awesome. But otherwise, yeah, the link is in the slides. All right, moving on to Q&A. So many questions. Some of them are like not so relevant, but they're pretty good questions anyway. So Andrew, yeah, if you can stay back a little, like
Yeah,
10
sure.
minutes more.
Happy to. Yeah, yeah, yep.
Yeah, thank you. So, is it always good to advise to elect for a family trust election from day one, or should we wait till just before the trust is making a loss, for example?
Yeah, good question. I think my general view is that if you don't need to make a family trust election, don't make one. Because if you don't need to, you don't need to. And it kind of nails your flag down. Your family group is defined. You've got to deal with all that sort of stuff. So unless there's a need to make one, I've seen many occasions where they're just sort of routinely made. But if there's no need to make one, I would be saying don't make one until you need to make one.
Because that could be a whole session on FTEs and the errors that have been
Yeah.
come out of making family trust elections.
Yes.
Yeah, and family trust distributions tax. Next question. Are there important points that we need to be aware of, Andrew, when reading a deed and, the difference between a family trust versus a unit trust?
Yeah. Unit trusts are a whole different kettle of fish, because you can have different types of unit trust. You can have a fixed trust or a non-fixed trust. Things can get really messy with unit trusts around losses, for example. But everyone with unit trusts kind of sort of looks at, okay, who's the unit holders? And they kind of just almost treat it like a company from that point, which is probably going to be correct most of the time. But you still need to look at the deed, and understand what rights the unit holders have, distributions of income, things like that. But they're probably slightly less important for unit trusts most of the time than they are for discretionary trusts.
Yeah, I think sometimes just because it's called a unit trust doesn't mean it's always fixed. It could be some
No,
weird hybrid thingies going on in the
absolutely.
background. So you got to
Yeah,
read every single line about how income is, to be distributed.
absolutely.
Next question is from Sue. If the trustee moves interstate, and this is about, I guess, where the trust is located. If the trustee moves interstate, say from Melbourne to Perth, do we need to update the trust deed where it is originally set up in Melbourne and governed by Victorian laws?
No, it would still just be governed by Victorian law.
Okay.
Yep.
Yeah. And this one was when we talked about residency. Christian has asked, I thought that an Australian company must have an Australian tax resident director.
Yes, it does. That's an ASIC requirement. Yep.
Yeah, that's an ASIC requirement, not really so much for tax
Yep.
purposes. Yeah,
Yep.
tax residency is different. Yeah. And then Susan has asked, what are the implications if the trust deed has no formation date? Ooh.
So no date down as the date that it started on. I mean, it goes to those points. Okay, I guess the first question is, does the trust exist? And I suspect there's enough evidence to say yes, it does, because there's trust tax returns, financials, ABN, all that sort of stuff. Do we have the terms? Yes, we've got the terms. Do we know when it ends? Yes. So it's probably not something that's a massive issue, not knowing when it started. One related point is about the settled sum itself, and pretty common just to not have the settled sum paid as well. The $10.
Oh, really?
Yeah. I'm a sort of a stickler to insist on it if I'm involved. But yeah. And then the question is, does that cause the trust to be, not valid, that sort of thing? But I think that the view is it doesn't. It still exists.
Mm-hmm, mm-hmm. But you want to do it
But
correctly.
do it correctly. Put a date,
Yeah.
pay the settled sum.
Yep. Yep. Here. This one's about rectifications. I have a deed that we needed to rectify, but it is written that the settlor has to approve. And the settlor was the original accountant who has since died. What happens then?
I think you'd probably have to go to the Supreme Court for guidance, because if the set law doesn't exist or passed away, then you can't give that approval.
Mm,
So I think, yeah, you'd have to go to the Supreme Court for guidance.
mhm, mhm. Okay, I might just choose a couple more. Um, a bit on Div 7A, this one from Michael. How do you trace money relating to pre-December 2009 UPEs and whether it remains in the trust?
Yeah, well, I mean, you look at the financials, I guess. I mean, if there's been loan movements, loan balances, then there's been a loan, even if that loan's been paid back, it had to be paid back within like roughly 12 months of the loan. Otherwise, you've got a problem. So, for example, you had a UPE 2008. In 2010, the money was lent out and it came back in 2015. You've actually still got a Division 7A issue that's sat there the whole time.
Yep, yep. Like I think you gotta quarantine it. Like try not to
Yeah,
touch it at
you
all.
can quarantine the UPE, but it's that you've got to keep the money still within the trust. So long as the second you start taking the money out to other entities, then you have a subdivision EA issue.
Yeah, yeah. So if you're really quarantining it, that means any money that goes out, you have to prove that it is not from that quarantine UPE. You got to
Well, the
prove that
only
it
the
comes
only
from
way,
somewhere
yeah,
else.
it would only be from like present entitlements. That's the only money you could have come out any other way.
Mm, mm.
So anything else is going to have a problem.
Okay. Yeah,
Yeah,
yeah, yeah.
yeah.
Mm. All right. Last question. What should I choose? Oh, you've covered this. What happens if you can't find the settle sum? Um, Testamentary trust. Beneficiaries and trustees being the same people. Are there any issues with this?
Uh, I've looked at this before. I don't think there is. I think there's a school of thought that sort of says, well, if the trustee and the beneficiary, like the specified beneficiary is the same, do you have a trust, essentially? Like it's like, well, it's owned by them and they're a beneficiary. But with a testamentary trust, they're not the only beneficiary. There's other beneficiaries. So there still is, like, the trustee is still not, they're not holding the asset for themselves. They're holding it on class on behalf of a group of people. And I don't think whether the trustee is the beneficiary or not, whether that shouldn't change anything to do with that.
Yep.
I think on ClearDocs, they might not. Well, I think one of the providers wouldn't let you set up a trust where if you were the individual trustee and the only named beneficiary, like it just doesn't let you spit out the documents. I think that was the concern, but I still think that the trust still exists, and it's not actually not an issue.
Wonderful. Yeah, we could go through all the Q&As all day because that's, this that's what happens when you talk about trusts. The
Yeah,
Q&As can just go
absolutely.
on and on
Yeah,
and on.
yeah.
But apologies, yeah, we're run out of time. And so maybe quickly before we finish up, Andrew, what is your number one key takeaway from today?
I think my key takeaway is just the confirmation about there are lots of lost trust deeds floating around, and it's all well and good until it's not. Until someone beneficiary blows it up or the tax office. So that's my key takeaway about if you've got those type of situations, you kind of I think you should be having those conversations with a client, telling them about the risks of it.
Yeah. So for the 30% of you that said you don't have it, yeah, go find it. Go ask the client for it. And somebody said it's like pulling teeth. So good luck with that. Amazing. That's all the time we have left for today's session. Thank you so much for joining us, everybody. And please put your emoji hands one last time to thank you, Dr. Tax, aka Andrew Henshaw. We'll see you next time.
Next time.
Bye.